Oh, really?
You're loading into a live stream allegedly. One moment. Setting up meeting.
We are getting the.
Done.
Really?
All right, everyone, you're live.
Thank you. Good morning. Thank you all for being here today. Let's begin with the roll call.
Honorable Sharon Keller. Here. Honorable Missy Maderi.
Here.
Mr. James Jim Bethke.
Here.
Mr. Alex Brennan.
Here.
Mr. Jay Cohen.
Here.
Honorable Valerie Tovey.
Here.
Honorable Brandon Creighton. The Honorable Richard Evans.
Here.
Honorable Bill Gravel.
Here.
Honorable Nathan Hecht. The Honorable Emily Miskell.
Here.
Honorable Joe Moody. The Honorable Reggie Smith. Honorable James Wood.
Going to turn your efforts to TIBC. Judge Gravel is also an expanding member of the judiciary. Like Justice Miskell, Judge Gravel has always been willing to take on whatever jobs are necessary to improve the judiciary and the judicial system. I've known Judge Gravel for a number of years now, and I've always known him to be proactive in advancing the goals of the judiciary. Judge Gravel is currently the county judge of Williamson County. Before that, he was a justice of the peace in Williamson. In 2016, he was named Judge of the Year by the Texas Justice of the Peace and Constables Association. In 2015, his court received the Tyler Public Sector Excellence Award for Courts in America, awarded by Tyler Technologies. And at the 2015 Court Technology Conference in Minneapolis, Judge Gravel received the National 2015 CITOC Innovation and Business Process Award for contributions to the judiciary and technology and court business processes, presented by the Court Information Technology Officers Consortium. Like Justice Miskell, Judge Gravel began his service to the judiciary only about 9 years ago, and he also became immediately known nationwide as someone who went over and above the requirements of his job to improve the justice system. We are really delighted that these two knowledgeable and energetic jurists are going to be with us on the Defense Commission. Judge Maderi, did you have some comments?
Yes, I did. Thank you very much. Are we going to be able to fix that for the rest of the meeting? Okay. So as you all know, I chair the Grants and Reporting Committee. And so what I did was we had Judge Keller and got going over a dry run for this. And we were talking about how we have to kind of revamp the committees. And so Alex is going to continue to chair the Policy and Standards. And then Jim Bethke is going to be on that committee as well. Commissioner Covey, I had left a message for you, but I didn't know if you wanted to be on that committee. If you do, just give me a call. And then Richard, Judge Evans, if you would be on that committee, that would be great as well. Would you do that? He looks happy. He looks happy. All right. At least he didn't, jump off the meeting. Thank you. And then, leading the grants and reporting, I spoke with Judge Miskell, and Judge Miskell is going to take over on the grants and reporting as the chair of that. And then Judge Woolley is also going to be on that committee. And then Judge Gravel, thank you very much for accepting that. We also decided and kind of talked about this, being an active district judge, sitting on the judicial council, sitting on TIDC and living in Corpus Christi. We thought it would be a good idea to put a vice chair on here. When this committee was started years and years ago, there was a vice chair, but I guess before my time, it just kind of weaned itself off. And so since Jim Bethke has been on this committee or has been the executive director before, he knows a lot of information. I enjoy working with him as well. And so I've asked Jim Bethke to be the vice chair of TIDC, and he has accepted. So thank you. So to everybody on the committees, I am, first of all, Judge Keller, thank you for your very kind words. There's definitely big shoes to be able to be filled, and I'll try to walk as straight as narrow as I can on them. So thank you very much for your trust in me. I was just getting used to that feedback. I was kind of in the rhythm on that, right? So I want to say that I'm very, very excited to take over TIDC. I will do the best that I can. My door's always open, my phone, call me at any time if there's any type of issues. I think we're all here to do what is right for this commission. So I am thrilled to have everybody here working together for the common good of what we do. So thank you very much. Thanks.
Thanks, Judge. All right, moving along, it is time for the director's report. Scott?
Thank you, Judge Keller Maderi. So I wanted to let folks know that we have a new hire. Cody Huffman joined TIDC on December 2nd. Cody? Hello. Cody, there's Cody. He joins us from Smith and Bledsoe Family Law in Austin. He graduated from St. Mary's Law in 2023. And so, yeah, we're thrilled to have Cody. He's, I've been hanging out with him for a couple of days, and I know he's going to fit in really well. So welcome, Cody. Recent activities. We did some presentations at the American Society of Criminology and the Indigent Defense Research Association about a month ago, and it was I was blown away by how much Texas was represented there at these presentations. We had TIDC staff on a couple of presentations, Public Policy Research Institute talking about our rural study and our salary work group study. The Decent Center was there as well. So I was blown away, and I think we all should be impressed by how much Texas is really leading the way in a lot of ways on indigent defense. And it was shown there at this major research conference. Public Defense Days, Kristen is going to talk a bit about that later on, but we've been hitting all the law schools to try to drum up more interest in indigent defense, criminal indigent defense, as well as family representation. Our data website overhaul took up a whole bunch of staff time, but I think we're all happy with it, and it's only getting better. And Kristen, Dr. Gamble will talk more about that. Here in a moment, we're going to talk about an MOU with the Department of Family and Protective Services that y'all have already approved us moving forward on in terms of, getting that process going. And so we actually have the MOU ready for your approval. And we also have a grant application regarding family representation that we're going to ask you to approve here momentarily. Operation Lone Star arrests were low in September and October. The out-of-state El Paso, you're gonna see a grant application from them here momentarily because of increases in OLS arrests. There was a legislative hearing that I testified in September on regarding OLS before the House State Affairs Committee. And I want to give y'all an update on our closeout of the LPDO OLS grant. At the end of 2023, the Lubbock Private Defender's Office, you may recall, their OLS operations were transferred to a separate organization, Lone Star Defender's Office. And since that time, we have been working with LPDO's new executive director to finalize those accounting books related to OLS and return advanced grant funds to TIDC. In November, LPDO returned $501,200.04 to TIDC. And on November 22nd, we informed LPDO that $549,441.80 in advanced grant funds were due back to TIDC. And we are continuing to work with LPDO to get those advanced grant funds returned to TIDC, and we will apprise you of future developments in that regard. Legislative update, legislative appropriations request. I've met with the staff from the Legislative Budget Board, House Appropriations and Senate Finance about our budget request, an exceptional item. And I've also done some follow-up regarding our anticipated fair defense account shortfall with the LBB. Senator Zaffarini has agreed to carry our omnibus bill that includes all of our substantive bills, ideas that y'all have approved as of August. And fiscal notes, TIDC staff is working tirelessly with OCA staff on doing fiscal notes for the next legislative session. Before we go to pending legislative proposals, we need to move things around a little bit because there's a grant proposal that we would like to put before the board that we would like you to approve. That grant application is due to the funder at 11 a.m. So we have 45 minutes, 44 minutes. What's that?
You don't think we'll get there in time?
I think we should probably front load that item. And the MOU, I think, as well, and then maybe we come back to the other family representation stuff to make sure we have time to get it in. So I'm going to turn things over to Crystal Left-Pignon, who's going to talk about the, would you like MOU first? We're going to talk about the MOU first with the Department of Family and Protective Services because it kind of interacts with the grant application. So Crystal.
Thank you. And yes, we have 44 minutes to do this. Thank you for that. So if y'all move to page 106 of your board book, we'll just go right over there and get right into this MOU. As Scott mentioned, the MOU and the grant application do complement one another, and the MOU is an integral piece of the grant application. So some of y'all may remember, and I know newer board members probably don't know about this, but short summary, there's this federal money through Title IV funds that historically has been around for all kinds of things in child protection work, foster care, paying for lawyers for BFPS, that sort of thing. 6 years ago, the federal government opened the money up to support representation for children and parents in CPS cases. So that was a big shift. It's an entitlement program and it's a reimbursement program. So if you whoever, it can be in our case, it's counties, but in other states, it's, legal aid providers or nonprofits or public defenders or whoever's providing this service. If they spend to pay for representation for children or parents, they are entitled to a percentage back. And it's for the legal representation, it's about 50%. And then there's this very complicated foster care penetration rate that's involved. So it's not a full dollar for dollar reimbursement, but it is money that's available that historically Texas has unfortunately drastically underutilized. At any given time, we've only got about 20 counties that are accessing their funds. And it's most of the counties aren't the large ones. I think Bear County maybe has finally kind of jumped in the mix, but for the most part, it's more sort of smaller mid-sized counties that are accessing these funds. And we have been communicating with DFPS for quite some time about the process and how does this work and trying to understand what are the barriers and why is this happening? Because in the CPS world, I'm sure Justice Miskell's heard about this, everyone likes to talk about 4E, but nobody knows really how to get the money. So in our conversations with the department and the Children's Commission, there were some thoughts that perhaps TIDC would be well suited to provide more supportive services to the department. Real quick, the way it currently works, if a county wants to get their reimbursement funds, they have to go directly to DFPS. 4E funds come through the Title 4E agency, which is your child welfare agency in every state. And they just contacted the department and then it goes through their contracts department. And, you know, these are people that are handling all kinds of contracts, they're not lawyers. And it's, you know, it's not the best, most efficient system. And DFPS, you know, they don't necessarily have the capacity to manage 200 and something 4E accounts, if you will. So back in April, the board allowed TIDC staff to negotiate an MOU with the department, and we've been doing that. And we actually have a real MOU for you. I used to represent the department many years ago, so y'all may not share my excitement for this, but the fact that we have got this done is like a big deal. So I'm very excited that we have this. And what this MOU will do, one thing to also let you know, because this has been sort of a moving target over the last few days. When we submitted the board book, the MOU language at Exhibit 108, that the way we listed it in the board book is we said that's the language that we had submitted to DFPS. There was, you know, some back and forth. OCA's reviewed this. The language that's in here is what came back from DFPS back to us. It's been reviewed by legal. It's been reviewed by their directors that need to look at this. And this is the language that came back to us as the final MOU. So
how does that, thank you for your work on that, by the way, and I'm the county liaison for CPS from the Commissioners Court in Wilco. And you know, how did, I mean, is it gonna be more money or is it just gonna be knowledge that there is money, you know, to claim it? And do we go through this organization or do we go straight to DFPS?
yeah, so that's a good question. So back on 106, just so y'all don't have to read through this whole MOU, we do have a summary of the responsibilities of TIDC, DFPS, and both organizations. So what we're gonna actually do, and this is of course if capacity is available, and we're hoping this grant will help us with capacity, we're gonna be providing this technical assistance to counties. So instead of a county going to the department and trying to fill out their Excel spreadsheet and that contract person trying to communicate with county actors about what's there, their counties will come to us. That's sort of that's the idea for how this plan will work.
You're gonna do the paperwork.
Yes, but we believe we can leverage the IDER. So the information that counties are already reporting to us is very similar to what needs to be submitted for 4E. So if this MOU is approved, we will begin exploring ways to upgrade our website, leverage that, and really make it easier for counties to hopefully use that same information and use it for the 4E.
So how would a county know how much money they have an opportunity to claim?
It just depends on how much the county has spent.
Right, so it's basically your spend on attorneys.
Right.
That, just for attorneys, not for services, not for the judge saying you need to go get this done or that done to the parent or the child. It's not for any of that. It's just for attorneys.
For children and parents, yeah. If
Right.
counties wanna get, if a county, say the district or county attorney provides representation to the department in that county, they'll still need to go through DFPS for that, but that seems like a much more efficient system that's been working for many years. This would be for lawyers for children and parents. And it's more complicated, I think, because we have the assigned counsel list, we don't have a lot of offices, so it gets complicated for counties.
Thank you.
Yeah, so what would happen is the county would submit how much they've spent, and then they'll get a percentage back based on how much they've spent, essentially. We will need to collaborate with DFPS. We don't get to just do whatever we want. Any changes we make, we would work with the department on. Any changes to forms, they still have to approve because ultimately they're still gonna be on the hook. They're the ones responsible if something goes wrong. So they're putting a lot of trust in us to do this right. But yeah, any changes, but I've got a pretty good working relationship with the projects director that's over this. And so I think we'll have a lot of good communication and ideas for what we can do. Money will not be coming through us. That's another good thing. So we'll review the claims, eyeball them, make sure it looks right, do a lot of what kind of we do for desk reviews for IDERs. And then if it looks good to us, we'll let the department know, we've received this, we've approved it, it looks good. And then they will be the ones submitting it for payment, and then the payment will go to the county. And I believe right now counties are receiving their payments from the state comptroller's office, sort of how it goes. So we don't have to deal with any of the cash flow or anything like that. We're just doing that administrative support. And our hope is that we can create a really efficient system that's sort of on a time schedule, so it's less complicated. And we, if we have capacity, we'll do training, Zoom trainings, we'll provide training materials. We really want to create a clear program for counties in the hopes that in time, it'll almost be kind of automatic. To just click, submit, get your money. It's not difficult. So that's our long-term goal.
It's a good goal.
Yeah, well, we'll see. I mean, if we got the MOU, I feel like we can do anything at this point.
So this is all federal money
Yes. it's
that's going
federal.
through the state, and now TIDC would be, helping with that process.
Correct.
How much total funds are there,
Well, it's an estimate because again, it's dependent on how much is spent. Our estimate, and it is an estimate, is that we have left on the table about $8 to $10 million a year
Wow.
collectively statewide. Some counties it's more than others, depending on how much they spend, but that's our target for the amount of money.
My
we've
guess
got.
is that a lot of the smaller counties probably don't have the manpower to actually submit and go through it, and it's federal, so there's strings. So you gotta look at all of the aspects. So, you guys helping with it, the process, I think would benefit, especially the smaller counties, even maybe mid-sized counties like ours.
Y'all have the capacity to help all the counties, or is the goal
Very good
to be
question.
automated
Right.
in this way?
Right now with myself and Natalie, to really build a robust program that we want to build in the future, that would be difficult to do right now. We did ask for an FTE in our LAR, to specifically do this work so that, but that, if it's approved, that comes in September, right? So that would be some time. That kind of segues into the grant application, so it's a very good question, but the grant application is, an idea that we put together to deal with the capacity issues so we could start handling things much sooner and not have to wait on the ledge necessarily to do that. But even if we don't have staff to do the big program we want to do right now, I think we can do it at some point if we get that FTE. And there's still a lot of things that we can do now, even just improving forms, reviewing the counties that are currently doing their submissions. There's a lot of things we can do right now. Another thing that we'd like to consider is encouraging counties to use the money to put it back into the legal representation system. So Dr. Gamble and I have talked about putting a survey out, it's kind of doing some exploratory work now that we can do even if we don't have a full-time employee on it.
Okay, do we need to approve the MOU first?
Yes, I think we need to prove that before we get into the application.
Okay. Is there a motion to?
Good.
Okay,
Motion goes off the memorandum of understanding, TID or TDS.
thank you. For a second, any discussion? All in favor? Any opposed? Motion passes. Thank you. Okay, Crystal. Also, this is very exciting. I agree.
Really is.
Yay.
My little heart is so happy right now. Everyone that does CPS.
You'll
work
get
is
back
happy.
to us in a year. Yeah, I'll have your
I know.
Committees.
Yes, I think we're gonna do some really good stuff here, so. Okay, so the next piece of this that let's see. Okay, we got plenty of time.
Is there somebody back there submitting things?
I have it ready on my computer.
Okay.
Check an email from Jennifer though.
I did,
Okay.
yes. On page 115, we have the summary of this grant application. So it's a great segue from Mr. Cohen's question. This opportunity came out in October, back at the end of October 23rd, so it has not been around very long. This is through the Judicial Court and Attorney Measures of Performance. This is a newer group that is working on gathering information and data to better understand how to improve the child welfare court system. Nationally, there is a lack of studies and information on, quality legal representation. What are best practices? There's a little bit, but not as much as we would like to have, I think, to better understand how to best serve families and have a really good system. So this program is sort of trying to leverage grants to get more information on all kinds of different things. But our idea, and it's pretty broad, the grant application was pretty broad. It's sort of a twofold thing. You can suggest an improvement implementation. So it could have been anything really. We stuck to our lane, obviously, but suggest an improvement and then study it. So JCAMP came out with these measures. There's a lot of different ones in different categories, but they came out with these measures for different ways to study the child protection court system, essentially. So the other piece of this grant would be if you implement some improvement, then you use the JCAMP measures to study and evaluate that improvement. And that's, I think, sort of the hook for the JCAMP giving money out, right? They're like, we'll give you money, but you need to use our measures to study what we're gonna do. So our proposal would be to seek money and funds for a full-time employee to 100% work on the 4E program and really build up a very robust program sooner, and we don't have to wait on the ledge. And they would be doing all those things that we talked about, the training, the technical assistance, reviewing the claims, all of those things they would be responsible for. And we would ask for funds to support that FTE because, as you'll know, we currently don't technically have any funds. We hope that will change after session, but right now we don't. And the other piece of this would be that we would subcontract with PPRI. So they do a lot of work for us. They do great work. And PPRI would be doing the bulk of the data collection, the evaluation, implementing those JCAMP measures and that sort of thing. The idea that we have would be to study Title IV-E and group the counties into 3 separate groups. So one group would be counties that obtain their 4E reimbursement and use it for systems improvement. So they put the money back into improving their legal representation system for kids and parents. I don't know that technically a county has to do that. Ideally, that's what we would like counties to do, but I don't know that they necessarily have to. So we would encourage counties, if you're gonna get this money back, use it to improve the system. We would like to give counties suggestions. We don't want to necessarily tell counties what to do, but give them some options, different suggestions. That's where this survey might come in, just to gather some ideas for different things the county could do with the money. So that would be one group, but totally optional. They don't have to do it. The second group would be counties that access their $40, but do not put it back into systems improvement for kids and parents. So they're just gonna put it back in their budget and, do whatever with it. And then the third group would be counties that do not access their Title IV funds. So we do think as easy as we make the system, there will probably always be counties that just for whatever reason don't seek reimbursement. So that would be our third group of counties. And then we would look at them separately and sort of study different outcomes. So, and this does a lot of different things. It helps us better understand how funding impacts outcomes. It also helps us understand what you do with the funding. How does that impact outcomes? Because we don't have a lot of information in our state. And as we go forward in this work, we think this is a really great opportunity to get a good baseline set of data, when we potentially ask for more funding and more systems in the future. So that is the gist of it. The grant award is between $100,000 and $250,000. This is one change on page 115. I wrote, we will seek the full 250 after getting budgets from PPRI and getting our budget together, we're gonna be seeking just under 250. It's somewhere near the 230,000 mark. The first year is 6 months, so the base year is a half year, so the first year would be half of that. And then the subsequent 4 years, it is a 5-year grant, would be the full amount.
So it'll be just a little less than 250 for the 5 years you're
Yes.
requesting?
Yeah, we ended up putting all the budgets together. It didn't come out exactly at 250. And it is a pretty long running grant. They say 5 years, it's technically 4.5 years, but it's a great way to get a really wonderful data set and look at things long term.
So obviously you're very involved in CPS world, so you understand it, and you realize that the state is privatizing some aspects of CPS. How will this be affected by that, if at all? I know we're focused on attorneys here, that the county is providing to indigent folks that can't provide it, right? I mean, that's the crux of it. Is that gonna be altered? Because I know that Wilco's been looking try to look at the crystal ball to see when we would be included in that privatization for other aspects of CPS services, because it's not working really well. We have 21 spots for CPS case managers, and we had 4 filled at one time. So you can imagine the turmoil. And we've also made some improvements on our side of the operational set. But is anything that you're talking about here going to be impacted by that, you think?
I don't, because we're focusing on court-appointed legal counsel, which is not, so those of you that are not aware, the actual casework of CPS, so the caseworkers, all of that is at some point going to be fully privatized. It's called community-based care, and they're being rolled out regionally, and so each region is sort of run by a different private organization that procures a contract with the department. Yeah, so it's interesting.
With the exception of some aspects like investigation or, placement or something, there's some aspects that are not going to be privatized. So trying to work within that new world and then have all your folks bail because they don't realize that, hey, they could be still employed. We found it quite difficult. But to your point of one of these items being putting the money back into it. So we're a county that, has a good amount of cost for attorneys, okay? But we're also trying to find other solutions for the CPS world, okay? So that would be something that we could partner with you on in brainstorming on how we could use the money.
Sure.
Because our county is putting money into this thing called CPS, whatever, either through our legal aspect or other programs, we're trying to partner with the FPS. So anyway, I would look to, counties that are already doing things to work alongside you with this. Anyway, as far as putting the money back into the programs, which is what you're trying to get, I think, counties to do.
Right. Ideally, they would be putting it into legal representation and supporting that. And I will just add that as the state goes through community-based care, having high quality lawyers it's always important, but it's gonna be even more important because of, you're gonna have private companies that are operating under different systems throughout our state, providing services to families. And so the lawyers are gonna be the ones that are sort of the protectors of what's happening.
Right, but working along with CASA and others, and I know we're about out of time, so I'll keep it short. It's not just about hiring more lawyers, it's about making sure the system works the most efficiently so that you don't have to pay a lawyer 5 times to come back and forth to court because they didn't get done what the judge ordered. And so I think it's working within the system. So I'm glad you're doing this, and this will be very helpful, I think, to counties like Wilco and others that want to improve the system.
Right.
So-
Well, we, I'm glad our lane is legal representation.
I know. But you're asking us to put money back into that, and it won't be just for that. I think it'll be for the whole we'll be able to hire attorneys to do things efficiently.
Sure. Yeah, hopefully better counsel and things like that. So good
Mhm,
questions.
mhm.
Now
You better go hit.
I know,
snooze.
I gotta move quickly. So I think I've covered the highlights. One of the barriers we've covered, we already have the MOU, so that's great. This is a reimbursement program, so we would have to pay our person first and then seek reimbursement, but we don't know that that's necessarily a huge problem because we know the money would be coming back to us and we do have the funds available if needed. So that's not necessarily a huge problem anymore either. So I think I've covered it. Did I miss anything? I know I'm trying to cover this quick and it's a big topic, so.
So is it a reimbursement program because that's written into the portion, or is that just the standard we have? in
For
state of
the,
Texas?
for the grant, so
Yeah.
this is a federal grant, so this money comes from the it's a lot of words, Children's Bureau at the Administration of Children and Families, so that, the money's coming from there. And then it's subcontracted through a nonprofit that's gonna kind of manage the money. And the way this grant has been set up, I don't know why they did it, but they set it up this way where it's reimbursement, that's the setup.
So
of
it's
this
a
particular-
federal standard.
It's the way the grant is set up, is to reimburse. You have to spend the money first and then you get,
Right.
then you
I was
apply to
just-
get.
The only reason I'm asking the question, I think of smaller counties, and reimbursements may not be that big of a deal to our larger counties, but to some of our smaller counties, it may strap them financially if they're having to wait for those reimbursements. That's why.
Okay, I think you're asking a different question. So the 4E money for the county,
Yes.
yeah, that's the grant that I'm talking about is for TIDC to get money for a full-time employee. So that's reimbursement. The 4E money for the counties that we talked about on the MOU, that is also reimbursement. It's always been reimbursement
That's
because
what I
it's an
was asking.
entitlement program. It's not like a competitive grant where a county would have to apply and prove they can do all these things and get the money. It really is truly like, did you spend this on this allowable expense? If yes, then you get this much back. Yeah, so what our hope is, like you mentioned, the counties that might struggle with, gathering the data and the information, we're hoping, we already do so much data collection with counties, we've already done so much technical assistance to get the family rep stuff in, that we think we are in a good place to help teach the counties how to do this more efficiently.
All right, is there a motion to approve the submission of the
I'll
JPF
move.
grant? Is there a second? Any discussion? All in favor?
Aye.
Aye.
All right.
Motion carries. Thank you.
Thank you, Jeff. I'm gonna send this out.
Yay.
Few minutes.
Right, internet goes down now.
But. Crystal, you can go ahead and do that, but before we move on, I want to say, this reminds me of what the task force was like when it was new. Somebody came up with a big idea and worked really hard to make it happen, and that's what Crystal's doing. So thank you.
Good job, Crystal.
Thank you, Crystal.
Okay, Scott.
All right, so we're gonna go back to our original game plan, and if you go to page 17, you will see a list of pending legislative proposals. And so this is a combination of there is one new legislative proposal, Proposal 1, which we will cover first. And Proposal 5 is kind of new too. But there were some proposals from the last board meeting. You may recall that the board did not approve. Y'all wanted to do additional work, or we wanted to, on the capital items, for example, we were going to talk to the regional presiding judges to see what they thought about these proposals. And so we've done all that. And so we're back with those proposals, as well as a new Proposal 1. So Proposal 1 is, the goal here is to try to deal with this shortfall that we have in the Fair Defense account. This is a structural shortfall that is going to continue to exist to the tune of about $6 million per year. We are no longer receiving that amount of money from a juror pay fund that we used to get the excess balances in this account, and they would come to TIDC. And so for a number of years now, we've gotten $0, or, a couple of years ago or earlier this year, we got like 1.8 million, but that was for past years. All indications are we are not going to get that money anymore because of juror pay has increased. We haven't been getting it, over the past few years. So the combination of those two things, I think, means that we're never going to get juror pay again. And that's about $6 million. beyond that, if you go back to like FY18, we were getting about $4 million more per year in court costs, were coming into the fair defense account. And so the combination of those means we're about, $10 million down per year, in terms of revenue coming into the fair defense account. So proposal number one is to allocate a portion of alcohol tax revenue to the fair defense account. This has been done over the past couple of sessions for other types of causes. So a couple of sessions ago, HB 1256 passed, and that put 1% of the mixed drink tax, mixed beverage gross receipts, and mixed beverage sales tax. 1% of those went into specialty courts. A couple of sessions ago, HB 3345, last session, the Sexual Assault Victims Fund, they got 1% of those revenues. I did some estimates yesterday on how much money we are currently spending on alcohol-related indigent defense. And so this would be indigent defense related to representation of DWI first, DWI second, and felony DWI offenses. And based on my estimates, we're looking at about $30.6 million is spent in indigent defense every year for alcohol-related offenses. So this proposal would raise about $15 million per year. So it doesn't cover the full, cost of DWIs in terms of indigent defense. It would cover about half of that, but it would cover a bit more than what we are short thus far. So I have pitched this idea to some legislative staffers, and nobody said that's stupid, Scott. So I think it's a good idea. And so the first legislative proposal would do that.
One at a time?
Sure.
Okay.
And there's precedent for that too, right?
There is
Yeah, why don't you
precedent.
tell them that as well?
Last session, once again, Sexual Assault Victims Fund got 1%, just like this. And then the session before, specialty courts got 1%, just like this. So this bill is based on those two bills.
Is that continuing, or is this we get it until somebody else gets it?
It would be continuing as long as the law is on the books. We would continue to get 1% of those alcohol tax revenues that come in.
And where's it going now?
It would go to the Fair Defense account, which is our general revenue dedicated
No,
account.
No, I'm sorry, where's it going now? We're trying to
Oh.
change it to us.
It goes
So
to
where's it going now?
the general fund of it's a split of the city. It's
I'm
at,
wondering who's gonna be against it.
well, we are asking for additional funds as part of our LAR request, and that will need to come from general revenue. And so this is effectively like something we could tell the legislature, well, there is this bill out there. Our board approved this, proposal that would send 1% of the alcohol tax to the Fair Defense account. It would still be general revenue. There is going to be a fiscal note on it, but rather than
New physical.
just general,
Just redirect.
just coming out of general revenue, it's gonna be a revenue stream that will be, solid, will come in, every year unless, people stop drinking. And, it will be, coming into the Fair Defense account on a regular basis. And then we wouldn't have to go to the legislature to say, hey, the Fair Defense account is short, we now have this additional revenue that's coming in.
Can you check with counties to see if they have any?
I did check with the counties, because half of the funds do go back to the counties, but as I read the statute and the fiscal notes from past years and talking to the counties, the counties would continue to get whatever they're getting today. It's a 50-50 split between the state and the counties, but this portion would be coming from the state portion, not from the county's portion. So the counties I've talked to, they're good with it. They don't see it, negatively impacting their budgets at all. It would all be, state revenue.
It's state revenue, no matter how, it's just.
That is
switched
correct.
direct line. Yeah,
It would be a direct
A
line,
direct
a
line,
regular
as
direct
opposed to
line to
going
the fair
through-
defense account rather than going into general
Yeah.
revenue and then us having to go to the legislature and say, hey, can you give us more general revenue because the fair defense account, once again, is short compared to what it used to be.
Scott, the money that the counties get for this item right now, is it coming through TIDC or is it coming straight from the state?
The fair defense account money.
I mean,
So
like if we're getting reimbursed anyway and the counties don't care because we're still getting our money, we don't care which funnel it's coming out of. That's basically what I think you're saying. So
the alcohol tax,
this group, this organization is trying to set up a set way of getting that funding every year.
yes.
I mean, and that's basically what we're doing, which I
Yeah.
understand that, and I'm fine with that. From the county, right now, how are we getting our money?
It's
The general.
the
Just straight
comptroller,
from
the
the general.
comptroller, it goes to the state and then the comptroller, is my understanding, sends a check back to the counties from, and I don't know the formula and why some
It's coming
counties.
straight from them.
It probably,
not through
I assume
here.
it's based on like how much tax revenue came in from alcohol from particular counties and then they get a
Oh, I
check
see.
back after the fact. That's my understanding of how.
So if we
works.
sell it, we get it back. If we sell the alcohol,
The comptroller's
we have
office
the
has it
problems, we
broke
get it
down
back.
by county.
What do you say?
The comptroller's office has it broke down by county.
Okay. But it's coming straight from them.
Yes,
This would change it to come through how?
it's still,
It's
the
still
tax
same
still,
way.
it still is collected, still goes to the comptroller. But 1% of it would be basically shaved off the collections and sent to the fair defense.
So what it does is it specifically says this fund that we're getting in is going to be spent for that, as opposed to the ledge being able to spend it on whatever, because it's going into the general bucket.
Correct, correct.
Some would like that and some will not.
This is true. So, I think we have a good case, to be made that there is a significant amount of indigent defense expenditures made because of just DWIs. I'm not even getting into other offenses that may be alcohol related.
Right, family violence, any of those,
Right,
right?
Right.
Right.
Scott, tell them it's a user fee.
Right.
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 Okay, is there a motion to approve?
Move to approve.
Proposal number one, is there a second? Any further discussion?
Judge, could I just have,
Sure.
Scott, I'm new, so forgive me for asking, but from my time on being on the judicial council, we can have great ideas and great legislative recommendations and suggestions, but we have to have a game plan to get it through the House and Senate and to get the governor to support it. And it's not easy. Legislation is not an easy thing to get through, as we all know. Do we have a game plan? Or is it just we as a commission pass this and hope that a House member carries it? Or, how do we do that at TIDC? And I'm sorry to ask.
TIDC is in a unique position in that we are statutorily authorized to bring ideas to the legislature. And we do this every other year during even number years. We have a whole legislative work group process where similar to judicial council, but it's a little more open-ended in that people will bring ideas to us. They will be vetted. Anything that has opposition gets thrown away, and then the things that have consensus will come to the board and they approve of those things they want to approve that are related to the indigent defense system. And so we've been doing that for a number of years. After something gets passed, then yes, it is on staff to do that legwork. You're talking about going and finding legislators who would be interested in carrying those items. So
I didn't know if we just had like a champion in the Senate that's carried stuff for us previously or in the House.
well, we're working on champions. And I think Senator Zaf.
We're taking considerations at this time.
In the past, we've had people that
Right.
kind of our go-to people. that
Yes.
Are very involved in indigent defense.
Senator
Zaffirini.
Zaffirini, as I had mentioned, she's gonna carry our omnibus package, which includes all the proposals that went through the commission earlier. So she might be interested in this. There might be other members. I don't know. I haven't done a lot of shopping this idea around because it hasn't been approved.
Gotcha. Thank you.
Is there also I don't know, is there like a hemp tax or something we could get in on also?
I'm not aware of any hemp taxes, but I don't know.
Any further discussion? I'm realizing that, which is crazy. All in favor? Any opposed? Motion carries.
Okay, so item number 2, beginning on 19. This is the Manage Assigned Counsel Program Access to Juvenile Records item. This did not get through the board last time, not from, there was some feeling, I think, that there were still some things going on in Bear County that it wasn't clear that the judges wanted this. Bear County will be the only MAC that handled juvenile matters at this point. So Jim, do you want to talk about Bear County in this proposal?
Yeah, I'd actually ask us not to vote on it until we have an opportunity to really talk with the juvenile courts. Because this was actually not even my proposal that I brought forward, it was kind of some of the other MACs. Because right now in the state, we're the only private defender program that has a juvenile division. And it pertains to getting access to the juvenile records, which are confidential. And we have a dedicated person over there. The initial opposition was the General Administrative Counsel. And she hadn't like coordinated with me. She is subsequently retired. And then Bill Cox and I and a handful of other people, we visited kind of with Joe Nada and the juvenile court judge. Joe's the head of the probation department, really smart lawyer, and kind of walked through some of the issues that the previous General Administrative Counsel had raised, and we were able to get those. I didn't want to just push this through and then there may be opposition. So we ran some traps on it. And, you know, we've got consensus there now.
With the juvenile court judges?
Yeah.
Okay.
Or did you want to add anything?
I think that covered it, Jim.
Is there a motion to approve the legislative proposal number 2?
So move.
I'll
Is there a second? Any discussion? All in favor?
Aye.
Any opposed?
Aye.
Motion carries.
Okay, so proposal number 3, beginning on page 4. So this piece of legislation would effectively implement what the board has already approved in terms of our legislative appropriations request. So the board has already approved a program for loan repayment for indigent defense providers in high need areas, as well as an internship and fellowship program at TIDC. And so some legislation is needed in order to make that a reality. Did you want to lay this out any further, Wesley?
That probably covers it unless y'all want more details. I guess I would say the first part of the proposal is the loan repayment. It's based on existing programs, the physician loan repayment program within the higher ed coordinating board. So it kind of tracks that model that they use. And then the second is just clear statutory authority for us to operate a fellowship and internship program and provide funding to those chosen to be fellows or interns. If not employed by a program, we can fund directly. So that's it.
Okay. I guess the only thing I would add is just yesterday, the government liaison staffer for the Texas Higher Education Board called me. He said they didn't see any major issues with the loan repayment language that we have here. He is running it through legal, but from his review, there were no issues.
Okay, is there a motion to approve legislative proposal number 3? There's a second? Any discussion? Yes, this is another big idea that somebody worked really hard on and I'm very excited about. All in favor? Any
Aye.
opposed? Motion carried.
Okay, so legislative item number 4, starting on page 31. Who's laying this one out?
I think that's me again.
Okay.
I'll be quiet at some point. Okay, so this is actually really even more important now that we're gonna be getting into this 4E situation and making sure that counties have their payments done correctly so they can get their 4E money. So this proposal was presented to the board back in August. And we withdrew it for consideration at that time to do some cleanup, do a little bit of research, and bring it back to the board today. So the general summary of the proposal, just as a reminder, and for those of you that are new, there is a law existing. So this isn't creating a new law, but there is a current law on the books in the family code that says attorneys who receive court appointments for children and parents must be paid according to a fee schedule. That's already in the law. The problem then begins where the law takes you. So that section of the family code then directs you to go to another section of the family code that involves juvenile justice, which then directs you to go to Article 26.05 of the Code of Criminal Procedure. So then when you go to the Code of Criminal Procedure, that section is specifically tailored to payments for attorneys who accept appointments in criminal cases. So the current law that does exist, it says there should be a fee schedule, there has to be a fee schedule, although what should be in this fee schedule is very unclear. So what our proposal is that we would create a new section in the family code, in the same area where the law talks about the fee schedules for attorneys who take these cases. And what we would do is simply take Article 26.05 and tailor it specifically for attorneys who take appointments in the child protection cases. So what I have done on page 33, it looks a little bit different from the normal proposed language, but I wanted to make it clear where these ideas had come from. So the new section 107.0155, it's technically, it says new section, but this language is coming straight from 26.05 of the Code of Criminal Procedure. And anything that is highlighted in yellow would be language that's different from the Code of Criminal Procedure. And then I have in green explanation for what that change is. So there's no additions, it's just changes to narrowly tailor it from criminal defense to child protection work. I think in August, there were some concerns that some of the language in the proposed bill would potentially add new requirements for the counties to pay for things that maybe parents and children are not entitled to. Some of that language came from the work group. So what we did was we stripped any of that extra language. We just completely stripped it. And this is truly Article 26.05 with changes or clarifications. I made your change, Judge, that you want the grammar change, anything to make it, clear and cleaner and better. We do also have a very short memo on page 35, which cites some Supreme Court case law that does talk about a parent's right to court-appointed counsel all the way up through the Supreme Court and for any remedies that they may be entitled to in that court. So we believe that our proposal matches the family code and Supreme Court case law. It's not creating any kind of new requirements on the counties. This isn't going to be a whole new thing where counties suddenly have to pay lawyers all this money. It truly is cleaning up the law so that counties have better direction for what should be in the fee schedule, and there's just more clarity in the system. And I will also note for the members who are new, TIDC is required statutorily to receive fee schedules from judges every other year attached to our family protection plans. And this is how we discovered this issue, because as we gathered the fee schedules, we realized some counties didn't have a fee schedule or they submitted their criminal fee schedule. And that's when we discovered that this was definitely an issue that needed to be addressed. I know the Office of Court Administration and myself, we have also fielded calls from local jurisdictions about what do I do with my fee schedule? And then, all we can do is cite them to the existing law, but it definitely creates some issues for counties. And I would argue the counties need better direction so that we can have better pay systems. And especially as we move into providing funding, we're starting with the 4E, hopefully we'll start with state funding. We want to make sure that the pay is clear and the systems are clear so that if we're putting money into it, that it's clear for everyone what's going
So
on.
how does this additional language clear that up?
Well, it creates a law that specifically tailors fee schedules to appointments for children.
So it basically is telling them, you don't have to use your criminal list. You can come up with a different one for this.
Right, it's not the list, it's how you pay your lawyers. And so the way the law works now is a lawyer, when you read the law, technically a lawyer who say represents a child in a CPS case, the law says they need to be paid according to a criminal fee schedule.
Yeah, I was gonna add something. So in Collin County, when I was submitting these plans, the family code actually points to like the felony fair defense plan. And so Collin County pays criminal lawyers on a flat fee, which doesn't make any sense for a CPS case. And so then I had to go to our criminal district judges that do the felony plan and say, hey, can you attach this sheet to give us authority for our fee schedule for CPS cases, which has to be different. It can't be a flat fee. And so then like I had to go, push it with the criminal judges and get them to amend the fair defense plan and for felony cases to include our CPS attachment, which like that doesn't need to be done. So I think what this proposal does is instead of having to have a family attachment to your criminal plan, you would have a family plan.
Separate.
Yeah.
It allows you to have a separate one. Addresses this only. It's good. Sounds efficient.
Is there a motion to approve legislative proposal number 4?
I'll move to approve.
A second? Any discussion?
I have one thing. I do think I have a lot of concern that section E would require counties to pay for a lot of things that they currently don't pay for. I understand that the proposed language comes directly from a felony plan where a mental health expert would be a much more limited expense. It would be an evaluation. Whereas I think the language in section E, the state should be paying for the experts through the department. So for example, if a child's attorney says, I don't like the child's counselor that the department is providing, I'm gonna retain my own because this says I'm entitled to be reimbursed for reasonable and necessary expenses for mental health and other experts. So I'm gonna hire my own child counselor that can testify at trial and then submit payment from the county instead of going with the state's experts. So I understand that this language makes sense for criminal cases because experts aren't such a big expense, but I think my proposed friendly amendment would be to delete section E for the family plan.
I agree with that because that can be very expensive depending on who you pick and how long they treat the person. And right now the state is paying for that.
But in criminal cases, the judges put a cap on it.
And it's gotta usually be an
But-
ex parte request.
Right, but the CPS process just works entirely different.
That's
right.
I
So
don't know that it works that way for CPS.
in criminal cases, the county is paying for the experts anyway. In CPS cases, like if someone needs a drug and alcohol assessment, the state provides it. This would say, well, I don't like your drug and alcohol assessment, I want my own, and now the county's gonna pay for it. That has not ever typically been the way it's happened, and this, I think, creates a huge
I
budget
think you're gonna
problem.
have a bunch of counties pushing back on it.
Yeah,
Would it be possible just to say reasonable and necessary expenses and then allow the county to determine what that would be? And we can take out the expenses for investigation,
and mental health and other
Yeah,
experts,
just-
that's fine too.
period, after.
I mean, some judges,
Yeah, that's a good idea.
In a family situation, does a lawyer still have a duty to have an independent investigation?
No, it doesn't work that way.
Okay.
What if we changed it with Judge
you
Woolley
don't want the lawyer
to
to be on
May
the
as
hook for
well?
anything. And for that, and I get that, but I don't think it works that way.
Okay, so 2 friendly amendments. The friendly amendment would be thing 1, change shall to may, and thing 2, put a period after necessary expenses and delete the rest of the sentence.
Well, I am concerned that if we say may, it makes it seem like the county doesn't have to actually pay the lawyer. I mean,
Well, I guess the question really is who gets to decide what the lawyer's expenses are?
So we put it in our plan and it would be things like mileage if you're visiting a child client out of county.
Right.
They always would try to put like copy expense, so it was always kind of a constant grappling over what counts as an expense that you get reimbursed for. But primarily, a lot of these expenses would be travel that's required by your duties in the family code. But in our plan, we set limits on what we would pay for.
Well, maybe we don't change it to may, and then we keep it shall be reimbursed for reasonable and necessary expenses. And then from there, I guess it's the county that is gonna determine what reasonable and necessary
As
are.
determined by the judge.
Right, the judges in the plan would say, so our plan actually said, we don't pay you to travel to the courthouse, we don't pay you to travel, but we will pay if your child is
Do we
placed
need
out of
to-
county,
Do
we'll
we
pay you
need
to
to
go
have like
there.
a, incorporated by reference list of stuff like that, or do we just not even wanna do it that way?
I mean, that's why I wanted to delete E.
The whole thing, right?
Sorry, what?
Just have to ask for it before they, okay, so that's what's different than.
Depends on the county too, I think. I think your county probably doesn't require that. I think some may require approval before it just sort of depends on where you're at, but
And Krista, wouldn't this be addressed in the fee schedule?
should be, yes.
Yeah, so I'm thinking as the judges are approving the fee schedule, this is addressed. So I think really if we just put a period after expenses and we delete the rest, I think it's going.
What if in the fee schedule, there's a presumptive max for whatever it may be, and then if you need more, you have to go ask for it? Is that not?
So again,
I'm thinking
most of
criminal, so
the,
I'm-
there's a lot of expenses that the county doesn't pay for, the state is paying for them. Because in the CPS world, so I just wanna make sure that we're not moving those expenses over to the county's ledger.
Right, and that's why we didn't pass this last time, because I had the same concern that it was going to be imposing extra responsibilities on the county.
Right.
So I'm glad
Which
y'all
really
brought
a
this up.
state
And
fee.
things to be paid for that we're not going to be paid for.
That weren't going to be paid for before, yeah.
So if you.
The discussion, why not keep most of the language? Let's say the plan shall state which expenses are presumptively approved and which ones require prior approval.
So like shall be reimbursed for reasonable and necessary expenses
As-
according to the
As
plan.
approved to by, yeah,
Fee schedule.
or in the fee schedule.
Right,
Mhm.
yeah, in the fee schedule, I think would cover it up. And then it gives the county flexibility, but they still have to,
I mean,
Cause
the
they could
other-
say, I'm
hold
not
on,
paying for this.
The other tension, just to say it out loud, is the judges approve the plan and then the commissioners have to pay it no matter what. And so there's constantly a lot of conflict and tension between judges and commissioners on paying these expenses. So that's why I was trying to say less, because then you have your local judges just have to beef it out with your local commissioners on what your county is gonna do or not do. Does that make sense? Cause they also set the rates for repayment and those are all very different and kind of every county does it its own way. And so I think saying less continues to let every county sort of hash out their local compromises.
And what we don't want to do is ruin the rest of the bill by putting in a controversial section.
A death pill.
Yeah.
Yeah, experts is very controversial in the CPS arena, unlike I think criminal. So that's, I just.
So I
wanted to
guess we
flag
gotta
that.
really focus on what's broken that we're trying to fix by this.
really just trying to get fee schedule. I mean,
Let's focus on that.
intention is a county, every single county should have a fee schedule that's clear for how their lawyers who take appointments in these child protection cases are paid. That's really just the intention of it. And
But we don't need these.
So fewer words are better.
I mean, I'm concerned if we don't have E in there, that we're now cutting things out that lawyers have been paid for in some
But
counties.
we would have already negotiated that. We don't need this language because it would have been on the fee schedule. We would have already said we're paying you for mileage or whatever. We're trying to get these lawyers to do it. You know?
That's really what I was gonna say, like E, if we took out E, the rest of the proposed language still requires them to have a fee schedule. And our fee schedule always has had what mileage we pay for and what we don't and what the rate is and.
If you find that to be broken, then that's a different conversation.
I hear what you're saying, Justice Miskell. I've seen a lot of fee schedules and there's levels of what's available. And so we can't assume that mileage will be on there.
But again, are they having a problem hiring people? Because
Yes.
then they need to change their fee schedule.
Are we gonna have a model fee schedule or anything like that?
Ideally, yes, I think that would be great if this were to get passed. I would love for TIDC to put together just some kind of model for counties to use.
Just to adopt or not adopt, but
Right.
they're to help, so
That's
that could go on the model fee schedule too.
I just would say that as proposed, this legislation will never pass. You will have CUC, Council of Urban Counties, you'll have the Texas Association of Counties
They've all seen this though.
with Section E, and they're all completely fine with that.
They haven't been, it hasn't drilled down to what it really means. And that may be
That's
the problem.
possible.
And when folks like, you know, like the boots on the ground go, well, that could open up a world of Pandora's box of expenses that we're not paying for now.
Well,
We just want to make sure
this
that.
ties into what you were talking about, of the problems with privatization, is that many of the attorneys that represent parents and children are dissatisfied with the services that are being provided. And so this gives them the ability to say, oh, I get to hire my own.
I mean, I will argue this law this law exists, so right now, if you're gonna follow the law, you go to the criminal fee schedule and would technically, I guess, be required to pay this. You know, I don't know, is it like, oh, I don't have to because it's not tailored to child protection attorneys? Is that the angle that people are taking right now? I'm not sure.
I think it is, because I think they're saying, well, under the context of the Code of Criminal Procedure, that refers to a sort of criminal mental health expert, a criminal investigator, not the ongoing 1 year of drug and alcohol counselor, parenting counselor, family counseling, individual counseling, occupational therapy, like all these experts that are all brought into a CPF case that are paid by the state.
Right.
So how, can I make a suggestion? Because I know we can talk about this a long time. How about if we take out E for now? Or we stop it, we stop it at some point in the sentence and get the bulk of it done. Because that's really what we're after, is a fee schedule that doesn't mean criminal fee schedule. And then if there's a new problem that we're trying to solve, we can address that, I think. I mean, I think counties that right now are paying people to do mileage and reasonable expenses.
I think the version that was just up there that had the red line through, including through the end of the sentence. I think as long as you're not introducing the word experts as a new thing that people could ask to be paid for. I think if you just leave the period after expenses, then I don't think you're opening up this Pandora's box.
And I will change my motion to do that.
Okay, I'm not sure how to do this. Do you
That's
know how we accomplish this?
Wesley, how do we accomplish this?
It's just that my motion includes the language that we're seeing right up there. That is my motion. If there's a second to that.
Second that.
And we're voting on the amendment now, right?
Yes.
Is there a motion? I mean, there's a motion to second. Any discussion on amending the section E to put to
Period.
delete the red lined out part there?
And put a period after expenses.
Expenses.
I'm in favor of that.
All in favor?
Aye.
Any opposed? Okay,
I'm opposed. I think there needs to be something in there that says as is authorized by the presiding judge.
Yeah, the plan, it does. It says the plan is adopted by district courts hearing those suits, or the courts hearing those suits.
Yeah, because not just district, right? Because
Right.
we have county
County
court.
courts.
also
Yeah,
doing
that's
it.
section B.
Okay.
Judge Evans?
Formal action of the judges, right, under B.
So it takes care of that.
I think every judge would have to approve a voucher in most cases. An individual voucher.
Any further discussion? Now we're voting on adopt, now we are, oh wait, no, we're still on the amendment.
Yeah.
We voted on the amendment.
We haven't
We
voted
did
yet.
a first and second. but I
We
don't
did
have-
first and second, then Judge Evans had a comment.
Right.
So all in favor? No, we did, we already voted.
We voted, he voted.
You said no.
You voted no, okay. Now we can vote on legislative proposal number 4 as amended.
I'll move to approve.
So is that
Crystal, you may not see it now, but removing that in the red line actually will empower our judges to do that. That makes sense.
You mean
Yeah.
not pay people for things?
No, you're thinking about not paying people. I'm thinking that removing that will empower our judges to make that decision. On the local, for the local benches or the local administrative judges. They'll have the power to do that.
That's correct, yes.
I'll second
any discussion? All right, I'm kind of lost where we are. I think
We have a motion, a second.
Second.
for this, for
Any discussion?
this whole thing,
To approve all-
including the amended.
Approve.
Mhm.
Yes. Favor?
Aye.
Any opposed?
Opposed?
Okay, thank you, Judge. And motion carries. And thank you, Justice Driscoll and, thank you
Yes,
both
for
for,
pointing that out.
that's very important. I'm really, I brought it up. Okay.
We're now on to, let's see, how would y'all like to approach 5 and 6? So item 6 was a proposal that came to the commission through our capital, through the legislative work group. We had a subgroup working on capital representation, death penalty representation matters. It got put on pause so that the regional presiding judges could take a look at it and give their opinion. And so that was done, and the regional presiding judges were not in favor of that proposal that was brought to you at the last board meeting. And so that's item 6 is that original proposal that y'all put a pause on, and we said we would bring it back, and so we're bringing it back, but the regional presiding judges said they were not in favor of it would establish a statewide standards and training committee that was not, it was made up of a variety of folks. I think there was 1 or 2 judges on it. It was not a majority of judges. And so for a variety of reasons, they were opposed to that. Am I correct in my summary, Judge Maderi?
Yes,
Okay.
yeah.
So Judge Keller and Judge Maderi went over the proposal themselves, and basically did it does not establish a statewide standards and training committee. It does open up the statute in a way to allow one of the big issues here is there's not enough lawyers taking capital cases. And so Judge Keller and Maderi got together on item 5 and did their version of a bill that does not establish a statewide standards and training committee, but make some changes in order to get more attorneys on the capital lists that the regional presiding judges oversee.
So let me just start a little bit too. So what we did was we took this to I'm one of the presiding judges. So we took it all to the presiding judges, kind of laid it out for them. And none of the judges liked the new thing. Sid Harrell, I put on that subgroup to be able to work on. He's one of the presiding judges as well. When he walked in later on, he tells me basically they were already working off of I can't remember, Gherkins or whatever that bill is, right?
Hawkins had a bill from last session and the session before, and that was the starting point. That is correct of that proposal.
Right. And so basically what it looked like was that, so he was kind of stuck in like, this is what we're working on for right now. And so they all worked on that. I think Ben Wolf, were you a part of that as well, Ben?
I was.
Okay. And so they worked on it and then they came back with this. When we brought that to the PJs were really under the impression that we did not want this. But we also know the bottom line is we have to get more attorneys on this list. And so I talked with Judge Keller, we went over it, and we came up with some type of proposals on here. The other thing that I believe Judge Keller was the first to bring up is it pulls a lot of judges right off of this thing. And we want, this type of thing to be run by judges, and the presiding judges specifically, with our local select committee. So that's why we started looking at it.
Yeah, so we kind of recognized that the proposed legislation was trying to do 2 things that were contrary to each other, or at least seemed contrary. And one of them was to improve the equality of representation. The other one is to get more people on the list. We thought it's more important to get people on the list. So we've tried to amend the earlier proposed legislation to accomplish that. Yes, Alex.
Okay. You can't be for both of these.
No,
No, we're not.
It's either or, right?
Correct.
Okay.
Yes.
And what is Judge Harrell's position now?
Judge Harrell understands that he would rather have kind of the proposal that Judge Keller and I came up with. However, he was part of this group, right? But he was kind of like, when I went into this group, they've said, here's your pie, right? Go ahead and work with it. And so, but when I showed him the new thing, he said, I don't think the group that was put in charge of this will approve of it. But I didn't know if we knew.
What's the biggest pushback?
I don't know, Ben, you can probably let us know. I mean, I don't know,
You check on the earlier proposal,
the first one.
Yeah, the first one. Why did they say no?
the regional PJs.
Whatever group
I
is
think,
pushing back. I mean, why are they pushing back?
I think a lot of it was that it took the authority away from this group, which is
TIDC.
predominantly, the board, which is predominantly judges, and gave it to a predominantly non-judicial group to make the changes that this group has not done.
I see. But the second, I assume that's 6. Is that
6 is
the 6 or
Six
the
is the
original?
one that we are not in favor of.
Right, okay, but is 5,
I can't
Yeah.
tell.
is that right?
Yeah, 5
is what
should
you're in
be-
favor of?
Yeah, a 5 is one that we've changed out words for death penalty and put capital murder cases and those type of things.
We're trying to increase the authority of the local selection committee to do what needs to be done to get more attorneys on the list.
That can do the really hard ones, death penalty, capital
Yes,
murder. all
and
those.
one of the things that we did was, and this may have been the other plan, but I don't think so, to make sure that lawyers who have worked on death penalty cases and accumulated mitigating evidence so well that the DA decides not to seek the death penalty, under the current statute, they can't be appointed because they haven't presented mitigating evidence at a death penalty trial. Well, obviously, they're doing well at it, so we tried to make that change.
Right, if they're
Well,
convincing
they should
somebody,
be,
don't go to the death penalty, right, then
Yeah.
they're obviously very,
Enough, good enough,
and
well,
good enough at
Yeah.
mitigation,
right.
Yeah.
you know?
And Judge Harrell said, there is a shortage of attorneys that'll take these cases, and it's getting worse.
I have on the 5th region list, I literally have, well, I think 2 now just retired. I think I'm down to 2 individuals that are able to do that. Now, our jurisdiction's not doing death penalty cases, right now, right? But if another DA comes in or whatever happens, at one point, probably 10 years ago, I had they were going with the death penalty. I had no lawyers, right? And then I had to go down to the valley, right? Because my region includes all the way down basically to Mexico. I had to go down to the valley, find somebody who was, really good there, bring them up, pay for their hotels, pay for their travel. I mean, it was just, and we get the bills here a lot of the times. And I mean, it's a $220,000 hit to your county, right? And so we want people that can represent these individuals, because we need them. There's not, I don't think there's one regional presiding judge that has a list that is overflowing. And it's a lot of different things. I mean, even just VJs, right? Visiting judges, right? We are running out of visiting judges. And so it's kind of like everything. We don't have enough DAs. We don't have enough defense attorneys, right? But on this list, we don't have enough people that have done an amazing job with mitigation with their cases. And we need them to be able to be approved on
So
this
basically,
list.
you want to expand the pool
Correct.
with qualified people.
Mhm.
And so which one of these says that? I'm for that.
I think 5.
Okay, 5, good. I'll move that we approve 5.
I deal with the situation, and I've had this discussion with Susan Brown. She says you have to be on the list to represent people, even though they're not eligible for the death penalty. So like a juvenile, someone who's already been found, well, and there are plenty of cases where they're not seeking the death penalty.
Right.
Are they excluded? Do they have to be on the list?
I don't think I'm following you, Alex.
So if you had a lawyer that was representing someone in the juvenile courts and they went and certified them as adult, they're charged under the capital
Right,
murder statute,
right.
but they can't get the death
The
penalty.
death penalty, right.
Her position is then you have to be on the list to continue representing that person.
I'm not sure I'm following you, but it's not a fair bill, I don't think.
I don't.
Yeah, I see what you're
It's still a
saying.
capital murder case.
Right.
Yeah.
It's kind of like, it would be the same thing as if someone got arrested for a capital and the DA immediately came out and said, we don't prosecute
Yeah.
any death penalty
They
cases
never
here.
do. Yeah.
Right. They never do it quick, you know?
Right.
Which means then we have to put those attorneys on, which is another thing, right?
Mhm.
As soon as someone's arrested for a death penalty case, for the, some of you all don't know, right? The statute says, boom, you gotta put, two lawyers on this immediately, right? Well, it's just a churning of information. And then you have to go, even though, and we had this issue in Dallas, right? I think it was Dallas.
What's
Even
that?
though they say, I don't believe in the death penalty, I'm not gonna do it, until it's stated, you have to do that and the county has to pay for it. So,
But I don't think this addresses that. That's a problem. I don't
yeah,
think this
and I don't
addresses
think it does address it.
Okay. All right, I just wanted to know. I'm a little torn between this because I think the work group did a lot of good work and I support a lot of those standards.
Maybe what we can do, Alex, is, I mean, I don't know, unless we have to do something today, maybe what we do is we try to fix this to be able, I like 5, but I do like you coming up with that one and saying, do they have to be on the list or not? And then try to add something to it
I
to
just
deal
really
with
haven't
that.
spent any time looking at this, but if you could put it off, that'd be great.
Be fine.
I don't know.
Could we vote on, is the priority expanding the pool or is the priority increasing the qualifications?
What we could do, tell me that we could do this. If we want to vote on 5 and propose that as legislation, take Alex's idea later on in the process and go.
So I will change my motion to include that. So we will, my motion is for 5 with the authorization for you to work with Alex to address that issue. And I mean, if it doesn't change it a whole lot, I don't know that we are gonna have heartburn on that. Because the goal is, I think the goal is to expand the pool of
Yes.
good people. I mean, we want qualified attorneys, but not blackball them because of something that has been written into it before, you know, that doesn't really make sense.
And Alex's idea is to, is this right, to say, somehow accomplish the idea that if you don't have to appoint 2 attorneys right away, if it's not gonna be a death penalty case.
It may not be the law now, what she's saying. I mean, I do want to fight with her about it, but it may not even be true now that they're excluded because they're not on the list. But it could be clarified. That would, and I'm happy to work on that. Yeah.
Okay, so
So,
there's,
yeah, why don't we do that then? Why don't we
Okay.
have a motion, and then we'll take that motion. I'll second that motion.
okay,
And then Scott, will be able to meet with Alex and kind of improve, the number 5.
sounds good.
Within that limit,
Right.
within those limits.
Right, I mean, things change on that.
Yeah.
So.
Okay, that's motion and second. Is there any discussion?
I know it says death penalty in front of it,
What page are you on?
all of them.
All of them? Oh,
5.
But for
5, it is for 5. Yes. On the capital murder, I know currently in Texas, there is only capital murder, there's no other, but, Louisiana had the law that, repeat child sexual assaults. Kennedy v. Louisiana, the Supreme Court overturned and said, well, right now, the United States is not at this point. In the future, there may be other capital offenses that are eligible for death penalty.
So you want to take out murder and put just capital cases?
Capital felony, or capital cases.
Anyway.
There's a bunch of them.
Like
Right here.
in E, it just says.
Encourage the
capital.
legislature.
Well, I'm on 37. So death penalty or capital murder cases, and he's saying we should take out
A lot
murder.
of the other, yeah,
Cap
actually.
cases, I think that's a good idea.
Yes, showed a lot of.
You want it broad. You want it broad.
Right, because there is a chance that there could be something other than capital.
And we
murder.
need attorneys on all of it.
Right.
I mean, that's again, a broken thing that
And
we're trying
everywhere
to
else
fix
that
is
the
that we
statute
don't have
already
enough
has.
attorneys.
Right. No, I think that's a great idea. I mean, it could be changing laws on, aggravated continuous sexual assault of child, anything like that would be.
My motion includes that. We're gonna just vote
It's your
one time.
And I'll second. Well, I don't know if we're approving his or,
She made a new motion.
No, I pulled my other motion so you can only vote one time.
with the Woolley
Take out
amendment.
that. Yeah.
All right.
Who seconded? Any
Yeah.
further discussion? All in favor?
Aye.
Any opposed? Very good. That carries as amended.
We don't have to check the tape. on
Can you
that
read
one.
that out, Kristen? No.
You can,
New motion, scratch.
Is that real?
Well,
Well.
I mean,
Is there any motion? Second, if there's no
Motion, is there
fails.
a motion? to approve budget proposal number 6?
No, but we don't have a motion on the floor.
Yeah, is there a motion? No motion.
Oh.
Done.
Yeah, now can we just table it or?
Lack of.
I mean, I do want to say thank you to the legislative, to the committee that worked hard on that. You know, I think their hearts were in the right place for sure. Thank you.
Okay, Scott.
all right, page 50, 51, 52 really is just kind of a update on the legislative proposals that y'all have put forward. And some of the items that have been introduced already. Like I said, Senator Zaffarini has agreed to carry them all as a package, but we're still working to like get the individual items carried by members as well. All right, I think we are to the research and data website update by Dr. Gammon.
You, good morning, I think still.
Yeah, we're gonna have to probably have Cliff Note versions on a lot because we're running way behind.
Well, I have three things that will be very brief. The first is, you may have heard, we have a new data website. It is up and running. It has collected data for this round of indigent defense expenditure reports. Kristen was gonna just preview while I kind of continue. We're excited. We've had good response from counties. You'll see when she pulls it up. We still have, and not to steal from Edwin, a few counties still out there going to report. We are busy right now creating internal reports for TIDC staff to improve efficiencies. You know, and kind of creating new reports, some of the things that our staff have done by downloading and working on spreadsheets, we're now kind of queuing up. But this is what the portal looks like for those who are coming and logging in as a county. Kristen, if you'll show us that's just a preview of who has submitted. Again, this is more of a dashboard and kind of smart steps checklist that we've provided. And so you can see that the criminal and juvenile is the first kind of pie, the FPR, IDER, and then the OCA interpretation services reports that they help put into our IDER this year is there for them to understand how that's going as well. So that's just very broad overview.
And that's all back end stuff, right? That staff is looking at. It's not generally like the general public couldn't come and see this. This is for us to kind of monitor the status of what counties have submitted their reports, which ones haven't, that kind of thing.
It's county, you lump all the judges together in the county. It's just one, like, every county's got one set of
Yes,
numbers.
that's correct.
Is that
Every
right?
county is one piece of this pie.
I see.
Yes. So that's just, it's happening, it's working, it's going well. I'll let Edwin give more on that report. Attorney practice time was the other one that's been up and running and collecting data. This is what it looks like for an attorney to come in. It's still up, even though the time period is up. So if someone has taken an indigent case, they are supposed to come in and report this. And then we have reports that we've created attached to this as well. We're excited because this one's gonna grow, that we can queue in our system an attorney's name and kind of spit out what they've done historically forever for us, which will pull some cool research that we could look at differently. How long has someone been on the list? How quickly are people aging out, et cetera? We're not doing that yet, but we have some more tools to be able to look at that. So that's the data website. It's going well. The second thing is the salary study. We are preparing a report. Judge Maderi, Judge Keller have a copy. We will get you all a copy soon. We've had some outside interest in the state, outside of the state, and we're just repackaging this. It's nothing you haven't seen before. That will be available to you shortly. We'll send an email when it is. And then the last thing is, I just wanted to present to you some of the data from the State Bar supplemental survey that we were a part of this summer. They received 178 surveys, 490 of which are attorneys that took appointed cases. We just ran some general findings on this. We are going to maybe look at this within our own data set as well, but we found that the average age was 53 from the survey of attorneys who took appointed cases. They had an average experience of 23 years. They're overwhelmingly identified as full-time private practice. And then this is, you know, maybe not the greatest point of the data, but they reported approximate gross income. We couldn't get granular to find out who are the folks getting 40 as opposed to the folks that reported 130. This was all desensitized information, but we have the range of folks that reported income for court-appointed work with the average of 73,000. And so we're just kind of helping build our understanding of attorneys who are taking appointed cases. Is there any questions? That concludes.
Fine.
Sarah, just one real quick comment. I do want to thank you and the team for the IDR or the attorney practice time reports, because we submitted our first application for student loan forgiveness for a private defender who's for the last 10 years has only done like indigent defense work. And so we're able to kind of verify some of that information. So it is being utilized. So thank you.
Yeah, and we, because we do have a reception for Judge Keller in 20 minutes and a lot to cover, if folks could make it brief.
I'll jump in on page 54 of your meeting materials. Just have a very preliminary set of expenditure data on criminal expenditure reported by the counties. Up just under 10% so far. This is very preliminary. There are still some counties that are yet to report, but costs are up at least about 10%. We think that's going to go up a bit as counties complete their reports. Next few pages are just regular budget reports. The one that I'll spend a moment on is on page 55. This is reflecting the revenue into the fair defense account and the collections. There is a glimmer of good news in that court cost collections for the 3-month period of what are we looking at? September through November is up 9%. Now, 1 quarter does not a year make, but it is encouraging news that that is at least incrementally looking better than in the past. But the bottom chart on page 55 shows you what Scott referred to earlier, which is that our real revenue challenge has to do with our loss of juror pay, which has not changed. So we still have a structural problem, and that we're going to be working in the legislature to address. Page 56 is just an update on some previous budget years where we have a number of grants that are still open that we're closing out. And page 57, we're just getting underway with expenses in the current FY25 year. Not a lot of expenditures reflected there yet because it's early in the fiscal year, but obviously that's going to change. Let me jump to page 58 where we do have a motion, and I'll turn it over to Doriana Torres.
Thank you, Edwin. This is just our FY25 formula grant budget. So at the August meeting, we adopted the RFA, the request for applications, with no changes to the formula, which is on your page, and budgeted $17 million if there are no questions. We have a staff motion to award $17 million in FY 2025 formula grants to counties according to the policy published in the FY 2025 formula grant request for application.
Very good. Is there a motion?
No move.
Is there a second?
No second.
Any discussion? All in favor?
Aye.
Motion carries.
Wonderful. On your next page, I have a quick update on the formula grant special conditions. The special conditions are placed on awards with counties that are not in compliance with plan, reporting, and grant requirements. As of this morning, there are 2 counties that have not submitted their monthly court activity reports, Presidio and Terrell. OCA and TIDC staff are working with both counties closely, so we anticipate closing that very soon. As for the FY 2024 special conditions, since we printed these meeting materials, 5 counties have actually submitted the report, so we're at 30 counties. And that is the special conditions update.
Great. Thank you, Doriana. On page 60, so we have some housekeeping matters regarding grants, and then one new grant that we're going to be laying out for you. What I want to emphasize is that the new spending that's in the next few items totals just about $308,000. There's definitely available resources, in part because the FY '24 grants closed out. The underspending on those FY '24 awards is actually over $1 million better than what we had projected. So we have sufficient funds to cover all of the items that I'm going to run through fairly quickly. Please stop me if you have questions. On page 60, we have just a housekeeping matter. There was an error, that's a TIDC staff error regarding the continuing grant for Grayson County that was approved. This is for their indigent defense coordinator. We inadvertently calculated their eligible amount and we calculated it incorrectly. So we have a recommendation to correct that by increasing the Grayson County IDC program award by $8,550 to a revised total of $34,200, and that is motion 9.
Is there a motion?
I'll make that
Is there
motion.
a second?
Second.
Any discussion? All in favor? Aye. Opposed? Motion carried.
Thank you. The next 3 items are adjustments to some regional public defender programs, and this is related to countywide across the board COLA increases or salary adjustments that impact the budget for some of our sustainability grantees operating rural regional public defender offices. I'll remind the board that a couple of meetings ago, the board did approve some guidance for staff and policy that if counties made countywide adjustments of this type, typically COLAs, to county employees across the board, that those would be considered presumptively approved by the board, provided that we have sufficient resources to increase the impact on our grants. As I mentioned, all of these are covered under that policy, and so we are recommending them at the staff level. Page 61 is for
So wait,
Victoria.
come out on that. I don't have a problem with increasing it and I'll support these today, but I think that needs to be something that we explain when somebody applies for a grant. Because I know at Wilco, we've tried to improve that system because for all of our grants, not just, something that would come from here, is that we anticipate there'll be increases when you apply for your grant. So that when we do give something countywide, that they also get it.
Right.
Because in other grants, if you don't have it, you don't have the luxury of this and asking for more. And there's just, 3 or 4 counties asking for this today. What about the rest of us? What about the rest of the counties? And so I think the organization, we can tell them, hey, make sure that when you're applying for your grant, that you put in anticipate some increases are gonna happen.
Commissioner Kobe,
Yeah.
I believe that I'm working on a project right at this moment that will completely address your concern.
Good.
It is a training manual and resource manual for stakeholders and chief public defenders
Good.
in all of our new programs. It
Good.
will be rolling out at the issuance of our new grant period.
Thank you very much. I appreciate
Yes,
that.
ma'am.
Thank you.
Thank you for the point, Commissioner Covey, and I do want to let y'all know that these are all our sustainability grantees that are kind of on a renewal basis because they're going to qualify for the rural regional programs. And internally, we are budgeting, even if they don't tell us in advance, it's somewhat predictable. And so we are working in our budgeting process to try to stay ahead of that. But I think it's a great point, and we will be communicating with the grantees to plan for such cost changes. So I believe we're on page 61. Victoria County operates the Crossroads Regional Public Defender. It's a 4-county operation. Their countywide adjustment impacted the grant by $123,826. So we're recommending an increase to a revised award of $27,63,780, and that is motion 10.
$50,763,780.
That's right.
Is there a motion?
Approved.
For second? Any discussion? Favor?
Aye.
Judge, I do have a question. Do we have any schedule of what we're paying the chiefs and the PDOs that we fund? I noticed in Victoria, their chief salary is a little higher than what we pay in our hill country. Do we have a schedule comparison?
We do have the results of our salary survey that Sarah Gemmel was talking about a little while ago that documents the range of salaries for leaders in public defense offices as well as staff attorneys. I believe did we break out the chiefs in that? Yes. So we do have comparison ranges that we look to make sure that things are not outliers. And we do have some data about statewide spending across the board.
Do we have that, or can you give it to us?
I don't have it handy, but we could certainly distribute it to the board. It's in the salary,
Oh, it's in that,
It will be distributed shortly.
yeah.
And if you need particulars on particular counties and what they're getting paid, we have that data as well that we can provide to you, Judge.
I'm just looking at Victoria County, their chief is, I don't know what Jim Bethke makes, maybe he makes that much, but it looks like a lot of money to me. Just a comment.
And I will note, we did collect this for the current IDER. We do have 29 counties that have reported, so we will be annually updating this quartile as a part of our reports to have the most current data to continue to inform.
Okay, thank you, Judge. Thank you, Dr. Cameron.
Next item is page 67. Potter County operates the Panhandle Area Regional Public Defender, and they have basically a similar request. The impact for them is $45,960 increase in their 2025 award to a revised total award of $3,052,832, and that is motion 11.
Is there a motion? And second, any discussion? All in favor?
Aye.
Any opposed? Motion carried.
Thank you all. The last item of this sort is page 69 in your meeting materials. This is Tom Green County. They operate the Concho Valley Regional Public Defender Office serving 7 counties. And the impact on their award is to increase it by $52,396 to a revised total award for FY 25 of $1,913,350. And that is motion 12.
Is there a motion? Your second?
I have an amendment here because the motion and the recommendation mentioned the Panhandle Area Regional Public Defender. This is the Concho Valley Regional Public Defender. So if that motion could be modified.
I'm sorry, I must have been on the wrong page. I apologize. Page 69, the item is for Tom Green County.
Yes.
For the Concho Valley Regional Public Defender Office, my apologies. And it is motion 12.
With that amendment, any discussion? All in favor? Any opposed?
The motion was to
sorry.
change, we're on 12, right?
No, I think we just passed 12.
Motion 12, but
It's motion 12.
the
Motion.
language in the recommendation is wrong. In page
I
69,
apologize.
yes. So
Yeah.
it's just a typo.
Oh, I see.
There's a typo. It should refer to the Concho Valley Regional Public Defender in the
Start
motion.
over with the motion?
Leslie, do we need to start over with the motion?
I think it was amended to include Concho.
Okay.
I didn't hear the second.
I didn't hear the second either.
I heard Bob make the motions. Oh, Maderi, thank you.
Should be Dairy seconded. Any discussion? All in favor? Any opposed? Thank you. Motion carries.
Thank you. The last item, this is not going to have any cost impact, but Hale County that operates the High Plains Rural Regional Public Defender Office covering 13 counties is still in the process of getting off the ground and hiring staff. In the course of implementation and kind of the transition from the TIDC planning study into the implementation phase, they've run into a lot of difficulties in staffing and have requested to make some budget changes and staffing model changes. They were given guidance both by the oversight board of that committee, which is made up of all the participating counties and as well as TIDC to operate within the current grant budget and just make some changes to reallocate funds to make it work. And we've worked closely with them and they have done so. So they're staying within budget, but they've just kind of done these reallocations that are reflected on page 71. So no cost, but it does need board approval because the staffing model is changing to include a couple fewer attorney positions.
Is there a motion to approve the Hale County's no-cost budget reallocation and program staffing modification request pending receipt of signed request from the Hale County judge?
Second, I mean, if.
Second? You don't have to say that much. Discussion? On favor? Any opposed? Motion carries.
Item on page 73 is a housekeeping matter and also a cleanup from a staff error. When the board was presented with the continuing grant applications for FY25, there was one item on that lengthy spreadsheet that got dropped off somehow. That was our error. I apologize for that. But we do need you to consider approval of the continuing grant award for El Paso County's Padilla Advisal Program. This has been this is an award that the board approved previously, and they're in their fourth year of funding, and it was just inadvertently left off the slate of continuing awards for 2025.
I'll make a motion to award, continuing improvement grant to El Paso County of $73,697 for the El Paso Public Defender PDA program.
Is there a second? Any discussion? All in favor?
Aye.
Any opposed? Motion carries.
Next time on page 74 is a little more substantive, so I'll have to take a moment to walk through it. But as you all know, most of you know, I know we have some new members. The IDC has been providing funding for Operation Lone Star Indigent Defense, primarily through one large grant to our primary Indigent Defense Hub organization, which is now the Lone Star Defense Organization. El Paso County has approached us requesting funding for representation of Operation Lone Star defendants in El Paso County. Their original request was for $1.718,143,000. Staff had some questions about the budget. We've gone back and forth with them right up through yesterday to try to ensure that the budget was reflecting what's actually needed and was appropriate. We do have a revised request that did not make it into the meeting book that is less. And so the amount that's referenced in the motion number 15, you will see represents the staff recommendation of an award here for $1,494,636. There's a few $100,000 less than what was originally requested. And that adjustment is based on paring back the equipment budget and reducing the salary budgets for this program based on our work with the county to review the details of their proposed budget. So you'll see the summary that's on page 74. I can just kind of pause and see if there are questions or if you'd like to go into this in more detail, but the staff does recommend an award on the motion sheet. Motion number 15.
Is that of OLS?
This comes, I should also mention, thank you, Judge, that this comes out of Operation Lone Star funds, which are segregated from our normal grant-making funds. We have about $4.5 million of available Operation Lone Star funds that are currently unobligated that we would use for this. This is a 100% coverage grant, which is unusual for us, but is our standard for Operation Lone Star Defense. And it would be for 1 year.
Is there a motion to award El Paso County an Operation Lone Star Improvement Grant of $1,494,636 for the Public Defender Operation Lone Star Unit? Is there a second?
I'll second.
Any discussion?
Is this the same one that gave money back?
No.
Wasn't it the Lubbock?
No, so this is for El Paso County to have funds for the county to directly provide representation through their public defender office to defendants arrested under Operation Lone Star. The conversation we were referencing previously was the Lubbock Private Defender Organization that formally provided so that's a different organization, but it is OLS.
Any further discussion? All in favor? Any opposed? Motion carried.
And the last item for grants on page 80, I'll just quickly summarize that every year we issue the request for applications for our improvement grants. We're proposing a few very technical changes to the RFA to provide some additional guidance on equipment and the need to provide tracking and inventory of equipment. We've taken the language from the governor's office for their grant program to fill a gap in our guidance. So we have a motion to publish the 2026 improvement grant request for application. It's motion 16.
Your motion, is there a second? Any discussion? All in favor? Aye. Any opposed? Motion carries.
Thank you. I'll go to Deborah for fiscal monitoring, page 81.
When will it come in?
We'll be issuing that in January, the first half of January.
Okay, good morning. I will be really quick here. You can find the fiscal monitoring report on pages 81 to 85. And I'm just going to highlight, we went on 3 monitoring trips covering 7 counties and assistant county auditors across the state on preparing their IDER. There was a lot of effort into that. And that's all in the report, so we could go on to the next
Oh, I'm sorry. He's a new judge.
I didn't have any questions.
Great job. Improvement team.
Okay, thank you.
86.
Similarly, knowing the lateness of the hour, we've been very busy on the improvement team. We've gotten a new planning study request for the Nueces Mac we're working on. We've provided a lot of technical support to the High Plains Crossroads and Hidalgo Public Defender's offices. We've continued our work in Fiddle, and we've had a number of presentations, as you can see, in our report. And Kristen, is there anything you wanted to highlight quickly on our work with the law schools?
We're going to Texas law schools. We're talking about getting into public defense. We had over 220 law students that were able to make connections with leaders across the state. We had over 15 organizations work with us. And we also want to thank our partners at the Texas Criminal Defense and Judge Association for their continued partnership in this, as well as everyone at the law schools who makes this happen.
Okay, Leslie's gonna talk about the amendment proposals.
Yeah, on page 89, very quickly, at your last meeting, the board voted to publish proposed amendments to the policy monitoring rules, as well as publish them for public comment, which we're required to do every 4 years on all of our rules. Those were published October 4th in the Texas Register. We didn't receive any public comment and they're now eligible for adoption. If the board adopts them today, they'll take effect 20 days after notice is submitted to the register.
Okay, so we need a motion to adopt policy monitoring rule amendments as proposed.
This is an ongoing thing that we have to put out for public consumption periodically.
All state rules have to be reviewed and every 4 years and put out for public comment, and the agencies are meant to consider whether they are still needed and if there's amendments that are needed, and that was what the result of that was these proposed amendments from the August meeting.
Make a motion to.
Second. Okay. Any more discussion? All in favor? Aye. All right, so preliminary report on FY 24 appointed council data, Joel.
We will give a detailed report in March. Right now, we have just a very brief report on attorney practice time. You can see it on the table. Continuing on to a policy monitoring updates. Since the August meeting, we've issued 3 policy monitoring reports and we've received responses from 5 counties. I think I need to bring your attention to Dallas County because there was a board motion last time. Commissioner John Wiley Price had requested that we conduct a limited scope review of Dallas County's appointment procedures, and particularly in capital cases. And he wanted to also know if the public defender priority appointment statute was being followed. Our report made 3 findings. The first was that Dallas County did not always appoint 2 attorneys when private counsel was appointed in capital cases. The public defender, there was not always a written waiver or a written finding of good cause for appointing private counsel over the public defender. And third was an attorney was not always appointed from the regional capital list. Dallas County responded to our report in June. Staff had a few issues with the response. First, they said that as far as appointing 2 attorneys, that they would attempt to follow Article 26.052E, but if we expected strict compliance, they wanted us to specify. Well, since staff had made since we made the finding in the report, we expected strict compliance. The second issue was as far as appointing from the regional list. They said that they saw value in a regional list and they would defer to the mandate, but we didn't know what that meant. So we went to the P&S committee to ask for guidance since these were novel issues. And the P&S committee passed a motion to ask for clarifying information from Dallas County, and the board approved that motion. And so Dallas County has responded, and their supplemental response addresses our findings. It's on pages 99 and 100. If you have any issues with the response, please let me know, but I think it addresses the findings that we made. And that concludes the policy monitoring update.
And that's all for policy and standards.
And Alex, this answers your previous question about they have to appoint two unless the DA has provided a written notice.
That, yeah, except if they're juvenile, they're just not eligible for the death penalty, so that's different. And complaints, it's not under policy and standards, but yeah, complaints.
Morning, y'all. This is super quick. I'm gonna submit on the pleadings. I believe that the complaints report found on page 104 speaks for itself. We're pleased to see that complaints are decreasing from a surge in earlier this year. Thank you all very much.
Thank you.
Crystal?
I'll go very quickly. I just want to highlight a few things. I know we talked a lot about Family Rep today, and I do want to really thank everyone for being open to this. It's a big deal for people that work in child protection. I think we're gonna do really great things. So just want to thank you for that. I do want to highlight, we are doing a mentorship program, so on top of everything else, Natalie Corvington is doing an excellent job running our mentorship program. We have pairs going. Everyone seems to really like each other, which is great, and she's doing wonderful trainings for the group. And so I think it's a good initial program, and it's something we're doing with no money and is still able to do it. Other things to know as far as what's going on here, we can go all the way to the page 117. This is about the IDER. We'll have much more clear information in the spring at our spring meeting after we've done our full desk reviews of the IDER. But I wanted to just highlight one thing for y'all. In previous years, we have not done the attorney level detail report on the IDER. This year, we made that optional for family protection cases. In previous many years, that's been done on the criminal side. It's pretty standard on the criminal side. But this year, we made it optional for counties to submit their attorney level detail report, which is how much each attorney gets paid. We would like to make that mandatory next year for the counties. We had a lot of counties submitted just optionally this year, more than I honestly thought we would get. And so next year, we just want to make it mandatory. It is statutorily required in the statute. We're just trying to kind of slowly get counties used to doing these things. But that's it. I'll keep it short on this end.
I believe that we have reached the end of our agenda. Is that right?
Yes, it's from the next board meeting.
Oh,
April 4th is the next board meeting. It's already been set. Y'all agreed to it. That was gonna work for y'all. 10 a.m. to 12 p.m. on April 4th is the next board meeting here.
okay. Before we adjourn, I want to take 1 second to thank everybody that's here, that's working on this commission, and that has worked on it for the last 23 years. I am perfectly confident that I'm leaving it in excellent hands. It's been a highlight of my career, and I wish you well. We are adjourned.
Judge Keller's reception is right down the hall right now. So you just go out this door, take a left and go down the hall and you should see it.
Yes.
Great job, guys.
The bat by the door so that everybody.
Yeah.